The only thing that she did wrong at the day and time was drive a vehicle
with cocaine, alcohol in her system, beer in the car.
And there's a fatality as a result.
Yes, sir.
Can you please read to me what happened?
Yes, sir. This crash happened back on December 24th of last year. Officers were advised of a four-vehicle crash at 5:37 a.m. on the 6300 block of I-45 South here in Harris County. Investigators observed massive damage on a Chrysler, indicating a head-on impact, massive force damage on a Mitsubishi, indicating a T-bone impact to the driver's side. Officers spoke with a HFD firefighter who was on his way to work and observed the Chrysler strike the Mitsubishi. The Chrysler cut in front of him, causing him to swerve to the right and hit an Amazon truck. He states that this defendant was the driver and sole occupant of the Chrysler, and the driver of the Amazon truck confirms the wheel witness's story and stated that he clipped the Chrysler as he was coming to a stop. The complainant was taken to the hospital where she was pronounced deceased. Officers observed an unopened beer can in the driver's seat of the Chrysler. This defendant stated that she was the driver and that she struck the vehicle. They observed a strong odor of alcohol on her breath, red glassy eyes, and slurred speech. She was transported to the hospital, and a DRE arrived, and she was Mirandized and she waived her rights. She stated that an SUV was stopped in a lane and she tried to swerve to avoid hitting it and then crashed into the other vehicle. She admitted to consuming 4 to 5 12-ounce twisted teas and smoking marijuana.
And alcohol in the car while she's driving?
Yes, sir. SFSTs were done. She scored 6 out of 6 on the HGN. She did not have vertical gaze nystagmus, and officers observed a lack of convergence. They were not able to do the walk and turn and one leg stand due to her injuries of a broken arm and sternum. There was a blood warrant and residual search warrant that were done, and her blood, Your Honor, came back at a 0.025 for ethanol, and she had, yes, 0.25, yes, sir. And then she had marijuana and cocaine in her system.
And what's the offer of that?
We worked out an 18-month probation offer with 7 days as a condition, Your Honor.
That's not in the fact that there's a dead body in this case. Why is it not an intoxication?
It's a causation issue, Judge. We looked at it for an upgrade, is my understanding, because the other vehicle was on the roadway. Legally speaking, there's a causation problem, Judge, so that's why we came to the agreement that we have the families on board.
I'm not sorry, I'm not going to say it. You have a dead body here. She has cocaine in the system. She's got foods in the car while she's driving, and a dead body. I'm not down with that. No, we're going to have to do something else, but I would be remiss a week in jail where we have a dead body.
Yes, sir.
And to me, just because you're 9 months pregnant doesn't factor anywhere in my mind, Ms. Sanchez. Ma'am, look at me. While you're about to give life, you took someone else's life. I'm sorry. How many lives are now ruined because of this? Not only yours, how about everybody else? Every single day in Harris County, someone is maimed because of the DUI. It's sick that we lead the nation in fatalities. And I don't know why they can't prove causation to charge you with intoxication manslaughter. But to me, a week is insufficient. It's not enough.
Yes, sir.
So
we'll go back to the drawing board and get everything set, Judge.
But
yes, sir.
I'm ready to set this case for trial now. So unless we can work something out today, I'm saying it gets set today.
Yes, sir.
Okay.
All right. Thank you, Judge.
Your Honor, I understand that a fatality did occur, but the reason why they weren't able to charge my client with intox manslaughter is because this accident was unavoidable. If you're
Unavoidable?
Yes, sir. At the time of this accident, it was unavoidable. What ended up happening is that the deceased party spun out in front of her, and she was just going straight. The only thing that she did wrong at the day and time was drive a vehicle
with cocaine, alcohol in her system, beer in the car at a 0.20. Let me ask you something. Have you ever done breath test? Have you ever blown into a breath test machine? Have you ever done those wet labs? You ever done that?
Okay.
I'm serious, really.
Okay.
Have you ever done it?
I'll go one further, Your Honor. Before being a defense attorney, I was a lieutenant with HPD.
Okay.
So I'm above and beyond. I spent 3 years doing accident division. So not only did I investigated these. So my knowledge is probably more superior than anybody in the room. I spent 3 years picking up dead bodies. And that is a true and factual statement I'm making before the court. So yes, sir, I have.
I did, as part of training when I was a defense lawyer, I went to these classes where we took the breath test machines apart, did all kinds of experiments, did these drinking wet labs where you drink and then you blow into the machine. And the one time we did it, we downed a bunch of booze and I blew into the machine and I was lit, right? And I blew a 14 and I was lit, man. And all I did was I blew a 14, right? 0.14. She's at a 0.2.
0.025, Judge. 0.025.
0.02.
Yes, sir.
Okay. I thought you said 0.20.
No, sir. No, it's 0.025 with the cocaine and THC.
No, so she's not 3 times or 4 times over the legal limit, Your Honor.
We were discussing about Ms. Sanchez. We were discussing when for you to do your jail time. Should we have you do it immediately to where you have the baby in jail? Is that cruel and unusual punishment? But then again, is a dead body cruel and unusual punishment? What's fair? What's not fair? I don't know. All I know is that you're charged with DWI. There's a dead body, but they just can't prove causation. And that's why you're not charged with manslaughter. But the fact remains is that we have a dead body. How do we reconcile that? You're pregnant now, and I truly hope that you've treated your body well throughout that pregnancy. Because if you haven't, and you've used anything while you're on probation, you're guaranteeing yourself a life of babysitting of a potential baby that will have developmental, potential psychological, physiological issues that you'll have to babysit for the rest of your life, which is punishment in and of itself. It's not fun. You're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. The agreement that you guys have worked out is 30 days in jail as a condition to probation for 18 months. As part of the probation, does she have any prior DWI staff?
No, Judge.
Any other criminal history?
Juvenile history only, Your Honor, but nothing DWI.
What all were you wanting done on the probation? Correct.
Yes, sir. We are asking for DWI education class, a victim impact panel, guardian interlock, no refusal, no drugs or alcohol, random UAs, 80 hours of community service, and a $300 donation to MAP.
Is this how you understand the conditions, Ms. Sanchez? I will keep you to it strictly. I'm going to monitor you myself. You will report to me here to the court so that I make sure everything gets done well. If you are not in compliance, I will issue a warrant for your arrest. You will be put into jail, and then you'll be facing up to 180 days in jail. If you test positive for alcohol or any kind of drugs, I will put you in a treatment facility in the jail. Do you understand, ma'am? No alcohol, no dope, no driving. You must have what does she have now? Does she have a scram right now? Do we know if she's had any violations while she's been on? I don't think so,
I
right?
don't
She hasn't
see
any
any, Judge, no.
Okay.
She has a scram device at this time, Your Honor.
We're gonna have to figure out something about as far as the baby situation with the interlock or with the portable device. I will follow the state's agreement here. But like I said, I'm keeping you close to me. From now on, you'll be facing a minimum of 30 days in jail if you ever pick up another DWI. Do you understand? You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, if possible immigration consequence, you can be deported, excluded from the country, denied naturalization under federal law. Hey, if you can do the repeat offender DWI education class, did you say victim impact panel?
Yes, sir.
How many?
One.
One victim impact panel. You will be required to do a TRAS, which is an evaluation to see what other conditions you may need. You must fulfill those conditions. Guardian interlock, no drugs, alcohol, random UA. When are you set to deliver, ma'am? What day?
August 28th.
When do you think we should do the time?
If I could request anything, Your Honor, it'd be the beginning of the year, in January 2025, the start of the year. That gives her time to nurse her baby and everything else.
She must get it done within 6 months. Okay. All right, ma'am, how do you plead to the offense, guilty or not guilty? I will find you guilty. We'll send you to the disagreement. Good luck to you, ma'am.
Thank you, Your Honor. The state will pass the witness.
Let's see that now. It's what, 11:02. Okay. Mr. Flood, you ready?
I'm sorry, did the state pass?
State pass witness. It's
All
your-
right. Yes, I'm ready, Judge.
Okay.
See where to begin. You saw the video that we all watched of you approaching Mr. Martinez, right?
Yes, sir.
And despite your insistence on what you're telling, well, you told the jury that you asked him how much he had to drink, or if he had been drinking, right? That he admitted he had.
Yes, sir.
It's not illegal to drink alcohol and then drive if you're not intoxicated, right?
Correct.
Are you a drinker?
No, sir.
You don't drink any alcohol.
No, sir.
Okay. Do you think everybody that drinks alcohol and then drives is guilty of DWI?
No, sir.
So you said you were out that night as a speed to look for speeders.
It was a traffic enforcement. Yes, sir.
I think you said you were out there looking for speeders
Yes,
and also drunk drivers.
yes, sir.
So you were like the speeding and drunk driving enforcer that night.
Correct.
Are you familiar with the saying that when you're a hammer, everything looks like a nail?
True.
So that was kind of your role that night. You were out there looking for, it was the night shift.
Yes,
You're
sir.
looking for people to arrest or pull over for DWI, right?
Correct.
And you happen to find someone who looked like a nail. He was speeding and you smelled an odor of alcohol, right?
Yes, sir.
Now, you wrote an office report in this case, correct?
Yes, sir.
And you wrote that close in time to when this happened, right?
Correct.
You bring a copy of that with you?
Yes, sir.
Okay. I saw you kind of looking down earlier. It's okay to refresh your memory because I know it was a little time ago, but can I just ask you, you don't read directly from it
Correct.
word for word, but I mean, if you say, hey, do you mind if I refresh my memory? That's fine. Okay.
Okay.
You stated that you smelled an odor of alcohol on his breath.
Yes, sir.
And that was when the state was asking you questions right here.
Mhm.
You didn't say I smelled a strong odor of alcohol.
Correct.
You didn't say I smelled a heavy odor of alcohol. You just said I smelled an odor of alcohol,
Okay.
right?
Yes, sir.
You could have said, when they said, what did you smell? You could have said I smelled a strong or heavy odor of alcohol on his breath, right?
That's correct.
But you did not say that.
That's correct.
But you'd agree with me anyway, though, that just having the odor of alcohol on your breath, that doesn't prove a person's intoxicated.
That's correct.
Everybody knows that, right?
Yes, sir.
It doesn't even tell you how much alcohol a person has consumed, right?
That's correct.
Even if you said a strong odor of alcohol,
Here's the brutal paradox. A dead body, proven intoxication, but no manslaughter charge. The judge is stuck between law and conscience, and you can feel the frustration. This is where viewers need to ask themselves, is justice about what's provable or what's undeniable? Stay with me because the conditions that follow are about control, not mercy.
That doesn't mean that, well, that person's really consumed a ton of alcohol, right?
Correct.
Okay. So he admitted to drinking. You smelled the odor of alcohol. That makes sense, right?
Yes, sir.
Okay. Him drinking and him admitting to it and you smelling it, that doesn't mean he was intoxicated though, right?
That's correct.
Okay. Now, I don't know who's, I mean, I'm 53, my hearing's not what it used to be, but he didn't say I had several. We didn't hear that. Are you telling the jury that that's what you heard? How old are you?
I'm 50.
Do you wear hearing aids?
No, sir.
Do you have trouble hearing? Has any of your family?
Sometimes in a courtroom, yes.
Okay. Family members ever said something like that, like they have to me, that you have to repeat themselves?
But sometimes.
After listening to it, I think once or twice, are you still trying to, I mean, you know you're under oath here, right?
Yes, sir.
And you're still telling these folks here that we all heard that he said, I had several drinks? Or do you want to change that answer now? Just tell us the truth. He never said several drinks.
Okay, correct. Yes, sir.
Well, they got this man charged with a criminal offense. You understand that?
Mm-hmm.
If you were charged or a family member, would you want an officer up there not telling the truth to a jury?
Well, in
Objection,
no,
Your Honor.
No, sir.
No, sir. Is that your answer?
Yes, sir.
So why is it okay for you to do that? You said it wasn't the truth.
No, I never said that, sir.
Did he say several drinks?
He said a few, yes.
Did he say, I had several drinks? Like you testified to under oath 2 times.
Yeah.
That's an answer, Judge.
Overruled.
Which is it? Because you just said no, he didn't say that.
No, he said few.
Is that fair to exaggerate facts or to tell the jury things that are not true?
No, because a few means several.
But he never said several. He
No,
never
sir.
said a few. You know, you play it again? I'll play it as many times as you want. Can you, if I played it again, can you point out to the jury where he said I had a few drinks? Officer, look, I'm not trying to trick you.
Mm-hmm.
This is important. We want to be fair,
Yes, sir.
right?
Yes, sir.
We want to be fair, right?
Mm-hmm.
Your job's too important to not tell the truth under oath, isn't it?
That's correct.
I mean, is it that important that you've got to exaggerate and make up things that aren't true just to try to convict this guy?
No, I'm not trying to convict nobody.
Well, then why aren't you telling the truth to the jury? We all heard it.
The video showed the truth.
Right. The video shows the truth.
Yes, sir.
You asked him if he had been drinking.
Yes, sir.
He said a little bit. Right?
I need to go back and see the video.
Really? It's not important to you? Did you watch the video before testifying?
Yes, I did, sir. Yes.
I just wanted to be clear about what happened. And we have the video, and then we have what you're saying the video said. And those don't match up, do they? Yes or no? Is what you told the jury match up with what is on the video?
No, sir.
How is that okay? That's not okay. You went up to him and you asked him, have you been drinking? And he said a little bit, right? I will play the video again. It's in evidence. Do I need to, or will you just agree with me that that's the truth? Because if you're not going to agree with me that that's the truth, you want me to play it again?
Sure.
You guys mind? Help me drive.
Your Honor, for the record, that's State's Exhibit 2 at the 2-minute, 34-second mark.
Mr. Martinez, these were stuck going 100 miles an hour. Going home? Where you coming from? Where? 59? We got anything to drink tonight? Little bit?
You stop right there. What, you said, how much did he have to drink? Have you had anything to drink? What did he say?
A little bit.
A little bit. He didn't say a few, correct?
Correct.
He did not say several, correct? Okay. So that's not a part of this case.
Correct.
Okay. Go ahead. Thank you.
In the order for the record, this is 6 minutes, 33 seconds. Please give it to 6:32.
Mr. Martinez, how much did you have to drink alcohol during? One, only one? Okay. You know I'm asking, back in study, alcohol.
You came back to the vehicle. You asked him again, how much have you had to drink tonight? And he said, one. And you said, are you sure? He said, yeah. He didn't say a few, right? He never said several, correct?
Correct.
Is there anywhere else on the video that he said a few or several?
No, there's a part of the video where it says honestly, yeah.
I'm sorry?
There's a part of the video where he says honestly,
He said,
yes. Honestly, yes.
yeah.
Or yeah.
Well, that's why I wanted to show you what the state showed you. And the answers that you gave don't match up with what Mr. Martinez said, right?
Correct.
Okay. We heard you ask him 2 times about drinking. Did he ever say he had a few or several?
No, sir.
But then why would you come to court under oath and tell the jury that? Why? That's, may I approach the witness, Your Honor? I've got copies of your offense report.
Yes, sir.
I'd like to show them to you. I don't know what you have, but you wrote in your office report, right, that you asked the driver if he had any alcoholic beverages, right?
Yes, sir.
We heard that. That's the whole purpose of having a body cam, right? So we see the truth. That's the truth.
Right.
Not what you're saying, right? Right?
Yes, sir. Right.
And he stated, what did you write? He had only one, and you put O-N-E, and then you put parentheses and the number 1 in there to make sure that there was no confusion in your office report that he said he had 1 drink.
Yes, sir.
You never wrote anywhere that he had a few or several, or that he came back later and said, well, honestly, I have more to drink. Is that it anywhere in there?
No, sir.
Is this the kind of police work that you are used to getting away with doing?
No, sir.
So you don't get away with this all the time?
No.
Or you do get away with it all the time?
No.
Yes or no? Do you get away with writing false office reports?
Let's move on.
On the back, you write again that you asked the driver if he had any alcoholic beverages. That's like 2 places. And he stated that he had only 1.
Yes, sir.
And you wrote the number 1, O-N-E,
Yes, sir.
and then you put parentheses,
No.
the number 1. Period. Anything about that I misrepresented?
No, sir.
You approached the vehicle and he was holding his license and insurance out the window.
Yes, sir. Correct.
You were going to ask him for that, right?
Yes, sir.
How in the world is that a sign of intoxication? You said he was bouncing it?
Yes, sir.
That's a sign of intoxication.
Well, usually drivers.
Is that a sign of intoxication?
No,
Yes
sir.
or no?
No,
Then why are you here trying to tell the jury that it is?
I never said that.
Do you remember 10 minutes ago when they were asking you questions and you said he was bouncing his license and you were trying to insinuate that that was weird or some,
That was an observation.
right, about like his mental or physical faculties?
Yes, sir.
So okay. You talked about NHTSA, right?
Yes, sir.
I know this isn't the manual you received, but National Highway Traffic Safety Administration, that's NHTSA, right?
Yes, sir.
That's an acronym that stands for the federal agency that is the authoritative body on how to administer field sobriety tests, right?
Correct.
And they give you an arsenal of 3 tools, 3 tests. There's an eye test, the horizontal gaze nystagmus, right?
Yes, sir.
You know the name of the other 2?
Yes, sir. Walk and turn, one leg stand.
Okay, 3 tests that you can use to administer, and as you said, to determine if a person is intoxicated or not, right?
Yes, sir.
And that's what you were intending to do. You smelled alcohol, you asked him if he would do those sobriety tests,
Yes, sir.
and he said no. People have the right to refuse those tests, right?
Correct.
And he invoked that right.
Okay.
He thought about it. He made a conscious decision and said no, right?
Yes, sir.
Which he has the right to do.
Yes, sir.
Now, what you decide to do if somebody refuses, that's up to you, right?
Yes, the National
Correct.
Highway Traffic.
It's up to
and
you.
Safety Administration.
Objection that's non-responsive, Your Honor. I asked a yes or no question.
Both of you guys are, it's just, don't get hostile. Ask the question, let him answer it. That's it.
Objection non-responsive.
What's your question?
I said if he refuses or submits what if he refuses, what you decide to do next is up to you.
Yes, sir.
Okay. So you intended to perform those tests, as you stated, to determine if he was intoxicated or not, right?
Correct.
But you were not able to perform those tests to determine if he was intoxicated or not, correct? You stated that, so in your training, you went through, you received a manual about the standardized field sobriety test, right?
Yes, sir.
And that talks about the history of alcohol in the country, administration of the field sobriety tests, but also a whole list, a litany of signs about how a person's driving that could also indicate intoxication, right?
Yes, sir.
I mean, there's 100 different clues they list that say if a person's driving like this, that could mean they're intoxicated.
Correct.
Did you know that speeding has never been one of those signs?
This is speed.
Speeding. Did you know that speeding has never been listed as one of those signs?
It says speed and braking.
Is everybody that's speeding intoxicated?
No, sir.
Only at night
No,
when you're
sir.
out there looking for drunk drivers.
I'm not looking for anyone.
Well, that's not what you said earlier, is it? You said you were out there looking for speeders and drunk drivers.
No, I was doing traffic enforcement.
Mr. Martinez, there's no evidence that he was swerving, correct?
No, sir.
You didn't testify to that, right?
No, sir.
You testified to everything you observed about his driving to the jury,
Yes, sir.
which would indicate that you thought he might be intoxicated, right?
No.
You didn't keep anything back, right? He wasn't running red lights, stop signs, swerving all over the road, right?
No, but he did a moving violation. Yes, sir.
Right, we all know he was speeding.
Correct.
That doesn't prove a person is intoxicated, right?
No, sir.
I don't know if you saw your radar in there, but all those people that were, well, when you pulled him over, there was nobody around him. There were a few other cars that passed. Your radar kept going like 77, well over the speed limit.
Yes, sir.
All those people intoxicated just because they're speeding?
No, sir.
Okay. We know that that was a traffic violation.
Yes, sir.
Was there anybody that called in, like to 911, there's a drunk driver out there
No, sir.
with respect to Mr. Martinez?
No, sir.
So other than just driving fast, there was nothing else about him driving that indicated to you intoxication?
No, sir.
Okay. When you pulled over, some people who are intoxicated, they keep driving for a long time before they pull over, right?
Yes, sir.
It shows slow reaction time, right?
Yes, sir.
There's nothing about how he acted that showed a slow reaction time. He put his blinker on, he pulled over, right?
Yes, sir.
Nothing about the way he pulled over indicated intoxication, correct?
No, sir, but he did straddle the yellow line.
Yeah, we heard you say that.
Mm-hmm.
Your opinion, because he pulled over to the left instead of the right,
Yes, sir.
that's not how you wanted him to pull over, right?
That's a safety.
Did you get on your bullhorn and say, driver, pull over to the right shoulder?
No, sir.
You could have, right?
Yes, but due to the
Yes?
lanes, safety, yes, sir.
You could have told him where you wanted him to pull over.
Yes, sir. I agree.
But you followed him, you put his blinker on, pulled over to the left, and that's where you stopped him. And then Officer Ponce, or was he your corporal at the time?
Yes, sir.
He actually showed up after you, and he helped block the scene,
Correct.
block that lane so it was safe.
Yes, sir.
He was out on the scene as well,
After the fact, yes, sir.
and he observed Mr. Martinez as well, correct?
Correct.
Now, I don't know how closely you watched the video, but you know that there's more things that you said that are not true when the state asked you questions. Do you know what those are?
Remind me.
Well, I mean, you wrote in, and you have your offense report, and Officer Ponce wrote a supplement, correct?
That's correct.
Okay. And Officer Ponce, is that how you pronounce his name, Ponce?
Yes.
He wrote what he observed of Mr. Martinez, right?
Correct.
You stated to the jury that you observed Mr. Martinez chewing gum.
That's correct.
Okay. Look through your offense report and point out the place anywhere in there where it says that you observed Mr. Martinez chewing gum.
No, I didn't have it to my report, no, sir.
It's because you didn't notice that. Officer Ponce did. Officer Ponce comes out, and he even, so you told the jury, they said, what else did you observe? I observed Mr. Martinez chewing gum. And then that was a sign he was masking, hiding that he was intoxicated.
Yes, sir.
Really? Really?
Yes, sir.
You didn't even know he had gum in his mouth. Officer Ponce comes out. I mean, eventually you did, because Officer Ponce told you, right?
No, I didn't notice the chewing gum.
Where is it in your offense report? Show me. Just show me.
Put it.
Where's it on the video that you observed gum in his mouth? Officer Ponce comes out. He asks you, did you watch this part? He asks you, did he have gum in his mouth? And you said, I don't think so.
It's a hearsay at that point. He's asking about another person. He's not going to hear.
This goes towards credibility, Judge, what he testified to earlier.
He's asking about somebody else's statement out of court.
I mean, I can ask what happened.
There's a question.
You weren't, you didn't notice gum in his mouth. The other officer asked you and notified you. He had gum in his mouth, right?
He did, but I said yes.
Right. And at first you weren't aware. And then Officer Ponce goes up to the car and tells Mr. Martinez, open your mouth, right?
Mm-hmm.
You saw that, right?
Mm-hmm.
And Officer Ponce looks in Mr. Martinez's mouth and he says, spit your gum out. You're not allowed to have gum in a patrol car, right?
Correct.
You didn't have any part of that. If Officer Ponce hadn't even observed it or asked him to open his mouth, you would have never known. But you're here today representing things to the jury that they're totally not true. I mean, the gum's an insignificant part, right? I mean, you're not trying to convict a person because he had gum in his mouth for DWI, right?
I'm not trying to convict anyone.
You're not. So you're here like testifying in a neutral capacity? Or are you biased against Mr. Martinez?
I'm biased, no one.
Unbiased.
Unbiased, no one.
So you're here in a neutral capacity.
I'm here just representing.
Okay, so if the jury, it's who decides whether or not it's guilty or not guilty? You or the jury?
I believe the jury.
Right. When you arrest a person, that doesn't mean that they're guilty of an offense, right?
That's correct.
You just had probable cause. I mean, it sounds like there may be a question about whether you even had probable cause, right?
Just a little repeat.
Your Honor, that's a legal conclusion at that point.
He was earlier making legal conclusions, was he not? Overruled?
I guess my point is that probable cause, you smell alcohol, you pull someone off the road, it's probably a safe thing to do, right?
Yes, sir.
If the jury says they don't think that it was proved in this case, they can say not guilty, right?
That's correct.
And nothing would happen to you professionally in your job if they said not guilty, right?
That's correct.
And since you're neutral and not biased against Mr. Martinez, whatever the jury decides, you would be completely fine with, correct? You say you're not here trying to convict them. If they said not guilty, you should be completely fine with that.
That's correct.
That's correct.
Mm-hmm.
So it's fine for whatever the jury decides, you'll be totally fine with.
That's an answer.
No, I'm curious as to, was there slurred speech? Were there bloodshot eyes? I'd like to know about the indicia of intoxication.
That's about where I was going next, Judge.
So
I'll get there. Sorry. Yep.
get on it, doggone
it. So let's talk about that. The state kind of concluded by they asked you, which is typical. Did you form an opinion about whether or not Mr. Martinez was intoxicated?
Yes, sir.
And you said, well, first of all, you said that he had slurred speech.
Yes, sir.
I mean, there's like less than 1 minute, maybe, or a minute of you talking to him. We don't hear any slurred speech on the video. I'm sorry.
I heard it.
On the video.
Yeah.
Seriously?
On the video when I was there.
You said he had quick answers. I mean, what's the opposite of that? Having slow answers?
Sir, quick answers to stay quiet. Yes, sir.
Well, if he was responding slowly, you'd say he was intoxicated because he had a slow reaction time in responding to your questions.
I never said he was intoxicated. I said he had signs of intoxication.
You never said that you thought he was intoxicated. That's the point. Because when the state asked you, what did you think about him? You said, I thought he didn't have his mental faculties, right?
Yes, sir.
And they said, why did you think that? And you said, because he said, I'm coming from 59.
Yes, sir.
Perfectly clear. We could all hear it. No slur speech. No speeding it out with a quick answer. Perfectly legible. I'm coming from 59. And that means that he didn't have his mental faculties?
The answer that he gave.
From 59?
Yes, sir.
That's what you're saying is evidence that he didn't have his mental faculties.
Yes, sir.
I think you said because he didn't say I was coming from a restaurant or a bar, you wanted him to say he was, I mean, whatever. And that's something you based your decision to take him into custody on?
No, sir.
Well, when the state asked you, what did you base your decision on? And that was one thing you said, right?
Mm-hmm.
Okay. Physical faculties, you stated that his balance was bad.
He stumbled when he stepped out of the car. Yes, sir.
Where? It's like we're watching two different videos. Where was his balance bad? Where did he stumble? Did we ever see that?
Yes, he did.
We did?
When he was coming out of the vehicle, he kind of like stumbled.
Dude, the guy gets out of the vehicle, he turns around like this and puts his hand on the car. Where in the world could he stumble in 1.5 feet space? He did not stumble.
That's what I observed.
I'm sorry?
That's what I observed.
You saw him stumble from the time he got out of the car to put his hand. You had a dash camera too that was in your car. So if he stumbled, there's a whole other camera that would show that, right?
Yes, sir.
Why didn't we see that? Why don't we see something that shows what you say is true?
That's not for me to present.
Whose job is it?
Unless,
I think you're putting them in a bad spot, don't you think? They're trying to prove what you say is true, but they can't.
mm-hmm.
Don't you see that? They can't prove that that he said he had several drinks or a few drinks. They can't prove that. You're making their job very hard. You get that?
Mm-hmm.
Is there something else you want to give them to help them prove that you're telling the jury the truth?
But it's all there.
It's all there.
Yes, sir.
None of us just see it. It's all there. He had glasses on when he was sitting in the driver's seat. You see that? But you're saying that you noticed he had glossy eyes
Yes, sir.
in the few seconds you looked at him?
Yes, sir.
Did you know glossy eyes is not a sign of intoxication at all?
No, sir, it's not.
You agree with me? Are you agreeing? I don't know. Look, I don't know what you're agreeing to or what you're not. Are you agreeing with me that I'm right, or are you arguing with me that I'm wrong?
No, red bloodshot eyes is glossy eyes.
I didn't ask that. I said glossy eyes through his glasses. Did you know that according to your NHTSA training, all the clues, glossy eyes are not a sign of intoxication?
That's right.
So you're agreeing with me?
Yes, sir.
So why in the world would you write that and try to tell the jury that's another sign of intoxication you're telling them? It doesn't even prove intoxication. Why? Why are you doing
I
this?
never said that glossy eyes proves intoxication.
They asked you to list. We're taking notes over here, right? You see us over here, we're writing things down. They asked you what signs, more than one time. Slurred speech, which we didn't hear. Glossy eyes. You said that.
Mm-hmm.
Are you saying now you didn't say it?
No, I said it.
You know that's a vital sign of people being alive. You have liquid on your eyes. If you don't, there's a real problem.
Mm-hmm.
You ever thought about it that way?
Not medical.
Well, then why are you trying to tell these folks that there's things that you probably didn't even see and trying to tell them that meant he was intoxicated? Doesn't sound like you're being real fair or neutral to me.
I never said that he was intoxicated.
You never did.
No, sir. The only thing that I
But
said
you
was
put
that
him
he
in-
refused the SFSTs, which that proved to me that he was intoxicated, hiding evidence of intoxication.
Okay, you never said he was intoxicated, but he refused the SFSTs, and that said he was intoxicated. I'm just repeating what you just said. Have you ever heard the saying, if you tell the truth, you don't have to remember what your answers were, or you don't have to remember what you said?
Right. That's true.
They kept asking you to tell us your opinion about what did you base your decision on, and you cited 59 for mental faculties, physical faculties. I mean, we didn't see any stumbling. Glossy eyes are not a sign of intoxication. I think you even said droopy eyes, didn't you?
Yes, sir.
I wrote that down.
Yes, sir.
For God's sake, show me where you wrote droopy eyes in any of your offense reports, probable cause affidavit, blood warrant. You called it in on your MDTs. Show me one place where you said when you wrote this offense report after this arrest that he had droopy eyes. Show me.
Listen to the report, no, sir.
First time ever today. You just thought you'd throw that in there?
No, sir.
Well, you did. You did. Yes, you did. You just decided you would throw that in there. Because you did throw it in there.
Okay.
Did you ever tell anybody that before today?
No, sir.
There's a picture of his mugshot that they have in color.
Mm-hmm.
This is black and white. If he's got red eyes, droopy eyes, wouldn't you want to show the mugshot in color to prove to the jury what you're saying is true? That'd be pretty powerful evidence, right?
Mm-hmm. Yes, sir.
You've probably been in it. Have you ever been in a trial before?
No, it's my first time.
There was no alcohol in the vehicle? That was a question.
No, sir.
the state asked you a question, did you form the opinion of whether or not he was intoxicated? You stated I wasn't able to do, or you weren't able to do the field sobriety test to determine if he was intoxicated or not, correct?
No, I just said that he refused the SFSTs.
Right. I'm saying you were not able, you said you do the field sobriety test to determine if a person's intoxicated.
Correct.
You were not able to determine if he was intoxicated.
Correct.
And you have stated twice or more, you never said you thought he was intoxicated.
Correct.
Okay. Okay. But you arrested him, put him in cuffs, and he was in custody. You even called it in on your radio, one in custody for DWI.
Yes, sir.
But you didn't think he was intoxicated. Correct?
Correct.
Judge, I've asked everything I can. I object to the, I don't know what else.
Okay.
Pass witness.
All right. May this witness be excused?
Yes, sir.
Yes, sir.
Okay. Thank you so much for coming and testifying. You're excused. Say nothing.
Are they subject to recall?
I'm releasing him.
I think it's a good time for a break. Would you mind taking the jury out?
All right, sure.
Let me get.
All right. Please be seated. Tyler, you said we had a motion.
I have a motion to suppress the arrest. No probable cause. I mean, I think there's no credibility at all with this,
I'm going to grant it. I'm going to grant this motion.
and all the evidence that came after the arrest.
Bear with me 1 second. Let me go to the potty. I'll be right back.
I wasn't.
This is the emotional gut punch. The judge isn't talking statutes anymore. He's talking moral responsibility. Pregnancy doesn't erase consequences. And listen closely. This isn't about sympathy. It's about impact. One reckless decision, one irreversible loss. Drop a comment. Should pregnancy ever factor into sentencing in cases like this?
Mr. Gamble, Mr. Payton, gentlemen, both of you are charged with cases in here. Both of you are charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You know, looking at your information, I see that Mr. Payton, both of you guys, and Mr. Gamble are also charged with aggravated robbery with a deadly weapon. However, your felony bond was $10,000 and yours was $70,000. I don't understand why. We will soon find out. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you. Okay?
Yes. On November 7th, 2024, the officer conducted a traffic stop on a motor vehicle after observing it violate Texas Transportation Code 547.602, which requires mirrors, and the officer confirmed 5 traffic citations. The driver was placed into custody for those citations, and the defendant, Payton, was sitting in the front passenger seat where a black extended magazine was observed in plain view between the defendant's feet. Defendants 1 and 2, the second defendant being Gamble, were both detained, and a probable cause search revealed a black backpack found to be concealing 2 semi-automatic pistols with a loaded round in the chamber, not in a concealed holster, and within the wingspan of both defendants, as well as 37.8 grams of marijuana.
Tell me about the ag rob.
So the ag rob for Mr. Payton.
The defendants, same day, on 11/8.
I just want to confirm, Your Honor. It looks like the ag robs are different days. For Payton, it's July 27th, and then for Mr. Gamble, it's August 26th. So they're 2 separate incidents for aggravated robbery. So to begin with Mr. Payton, the aggravated robbery on July 27th, an officer was dispatched to a robbery at a vape time store. and the complainant said an unmasked defendant came inside the store and the complainant buzzed him into the door. The defendant looked around and then walked to the door and let 3 other masked men into the store. One of the 3 men pointed a gun to the left side of the complainant's neck, and then the other 3 men took money and merchandise before running from the door. The surveillance video showed the incident and showed defendants leaving in a silver Kia sedan. Officers were able to trace the sedan back to a co-defendant. They were also able to see that the Kia had been involved in a prior traffic stop. In that stop, the passenger of the car was viewed in the officer body-worn camera. That person was the unmasked first person who entered the store and let the other 3 men into the store before helping take cash and merchandise. And to move on to yes.
There were multiple, I think it was this defendant, Mr. Gamble, was one of 5 suspects robbing vape stores. And there are multiple incidents of the robbery. So we can certainly read PC Judge, it's just very long, but we're happy to read it.
Is it the same MO where it's in, I mean, are we talking about just like an enterprise type situation? Like an engaging and organized? Okay.
So
I'm just, I give my question is I want to know how dangerous these guys are, and obviously we've got ag robs on both of them, perhaps even multiple stops of ag robs. So Mr. Payton, I'm going to find that there's probable cause to go forward with the case. I'm now putting an ankle monitor on you and I want to know where you are at all times. And I'm giving you a curfew of 7 p.m. to 7 a.m. I don't want you out in the middle of the night, and I'm barring you from going to any, just got to be careful in this life, man. You got but one. You end up with the wrong person. You hang with dogs to get those fleas. You're going to end up with a 40-year sentence back there. And I'm going to tell you now, living in a 6x9 for 40 years is no way to live life. You know what I mean? It's not. I'm also ordering you not to be in possession of weapons, not to consume alcohol or illegal drugs. If I find that you're smoking weed, you're using anything like that, I'm going to put you in jail. I'll deem you a public danger, and I'm going to make your bond so freaking high. Do you understand me?
Yes, sir.
How old are you?
17.
What do you do for a living?
I'm employed right now.
Why?
I'm trying to get my.
I'm now making that a condition of your bond as well. You and I are going to be so close, it's going to be ridiculous. I am making it a condition of your bond that you get your GED, and I'm going to bring you back in 2 weeks to see what you have done to get your GED. You need to start working on it. We have enough people in custody as it is, and what you do now will affect you for the next 40 years of your life. You start acting like a knucklehead out there, you're either going to be dead or with a 50-year sentence, and that's not a way to go through life. You understand? I will appoint your lawyer today.
And Your Honor, in regard to Gamble, it appears that the bond may be higher as officers presented the facts of both the current case as well as a separate case that's unfiled. It's an HPD case to which the defendant confessed to also being involved. So it seems there's also an ongoing investigation.
Do we know who put the gun to the neck?
It was the defendant as well, defendant Gamble. And he also put a gun to the complainant's face as they were stealing marijuana and other items.
You hear everything I just said over there, Mr. Gamble? Same thing applies to you, man. We have enough black and brown people in custody as it is. We don't need any more. You don't need to live life with a 40-year sentence because of some stupid scheisse, man. You know? Do you know if you're going to bond out?
I'm going to be talking to this mom later, Judge. So
Okay,
we'll have
if
to-
you bond out, I'm ordering you under home confinement. I don't want you out anywhere. Do you understand? You will get a GPS monitor on your ankle, no weapons. I don't want you to talk with any of the co-defendants in any of these cases. I don't want you two hanging out with each other at all. You know, you may be great guys by yourselves, but when you're together, perhaps it's a Tasmanian devil. No thanks. We don't want it. I'm going to tell you both of you now. I will do everything in my power to protect my Houston at all costs. And I don't care if you put you in jail at 17 and you're kicking and screaming and this. No. Do you understand? You were lucky to get out as it is on this type of charge, as it just count your lucky stars now, Mr. Payton. All right, so,
It's a felony pending until 17 days, we'll just roll it.
for sure. And then, Felicia, so GPS prior to release on Mr. Gamble, no weapons, no alcohol, no drugs, random urinalysis. Did you graduate from high school?
Yes, he did.
You did? Okay. All right, John, so I guess we'll stay in touch with Mr. Gamble. All right, Mr. Gamble, good luck. We'll just keep us in the loop about what goes on. Mr. Payton, I'm keeping you ever so close. I'm not letting you go far. Do you understand? Okay. I need him to fill out an application. Do you mind giving an application? I'm going to give you an application for an appointed lawyer. I'm going to have you sign a receipt of Victoria, and then I'm going to have you meet with Felicia for bond conditions, and then we'll have you take a seat in the jury box. Yeah, correct. All of them. Mr. Roberts Clay, how's jail? It's been a long time since I've had someone with this kind of drama. Let's go through your spiel. 9/25/24, evading arrest, and you pick up an FSGI. 11/9/24, assault of a family member, assault of a family member, assault of a family member, assault of a peace officer, assault of a peace officer. You get on bond, I guess, he's on bond for all those cases, right?
Yes, Judge, I see.
And now you've picked up another assault of a family member and an interference.
Those were two Bs filed, Judge, while he was in custody. So he was not out of custody. He's been in custody.
So in our case here, from November 9th, he has 3 assaults, and then he also has the FSGI in evading, the new assault and the interference that was filed on 11/13. Was that?
In 2022.
So they're older.
They're older ones that they just filed a couple days ago, but he's been in custody on our 3 assaults and the felonies.
So the felony assault, I see that he has not made bond on.
No, and that's why he was in custody, because he was in on those 2 bonds while they filed these two on him.
Yeah, 22. And the interference was also from 22. Do you know all the assault family members, are they against the same complaining witness?
No, they're different, Judge. 2022 is Asia Barrows.
What is that, a girlfriend?
An ex-girlfriend.
An ex-girlfriend, okay.
No,
And then,
it's just regular, no baby.
okay, so then the other 3 assaults that we have here,
The other 3, the newer 3 are baby mama, mother and sister.
his mother?
His mother and his sister.
Okay. Have we found PC on all those cases? Because I don't know if we have or not. Let me see. Yeah, it looks like PC's been found on all of them. Okay, so Mr. Roberts Clay, I want you to understand something, that I'm ordering you as a condition of your bond not to have any contact with any of the complaining witness in any of these cases. Do you understand? I'm also ordering you not to be in possession of any weapons, not to consume alcohol or illegal drugs. I'm going to randomly test you, and I'm going to put a GPS monitor, and I'm giving you 1,000 feet. I'm going to give you a 1,000 feet distance of where I don't want you to have contact with any of these people, any of the baby mamas, your mom, whoever else is part of these, the peace officers, anyone in any of these cases, don't have contact with them, don't go within 1,000 feet of where they live or where they work. There should be orders for protection on each one of these cases. So you have to understand if you violate these, then the state can and will file additional charges against you. You need to understand if multiple assault family members within a certain amount of time, they can hit you with third-degree felonies, and you can be looking at 2 to 10 of the penitentiary on those. So I don't know if you're going to get out, but if you do get out, I would be very careful where you go, because even if you have whatever contact, they can file more charges on you. I mean, you've got now 1, 2, 3, 4, 5, 6, 7, 8, 9 open cases. Shreya, the evading arrest and interference on all these assaults, those happened after.
Yes.
Right? So I'm revoking the bonds on those 2 cases. The evading arrest and interference, the FSGI and evading, I'm revoking those bonds because of all the new cases that he's picked up.
I understand, Judge, but the 2 new cases are from 2022.
That's why I'm not doing anything with those, right? So I'm not using those against him to revoke the bond, but the new cases from 11-9, those are after, we ordered him follow conditions. You have failed to follow those conditions by picking up another case, another 1, 2, 3, 4, 5 assaults. So because you picked up those 5 assaults, I'm revoking the bond on the FSGI and evading.
So Judge, is this his first court date since the November 9th?
Correct. Yeah, this is the first time that I've seen Mr. Roberts Clay. I have not seen him at all, but we've been literally rolling him day for day to try to get him here. And we had Marco Sapien representing him, trying to get Mr. Clay, Roberts Clay and Marco at the same time so that's why. Did you want to add anything?
What are the conditions currently, Judge?
So no contact, no weapons, GPS, no going within 1,000 feet of any of the complaining witness where they live or where they work.
Satisfied that, Judge.
Sorry?
That works, Judge.
And then I'm revoking his bonds on the FSGI and evading, and then that's it. So
What are you setting those at, Judge?
I think there should also be, I would ask that they also be set at 5,000, Judge, to mirror the others.
75.
5,000, Judge.
Oh, yeah, I was going to do 5,000 and 1, 2, 3, 5,005 on the FSGI and evading. And then I'll leave the others as is. Okay, Mr. Roberts Clay, you know what's expected of you if you bond out. Just don't go near anywhere of these people. Sometimes when you have cancer, what do? You cut the cancer out. If you don't, it's going to kill you, right?
Judge, would you do 5,003 just because I think it looks a little misleading whenever inside we're
Of
looking
course.
at it and
Yeah.
it looks like you picked up 5, but it's actually 3.
Yes, of course. These people may be a cancer to your life. They're killing you, man. Cut it out before it kills you. Do you understand? All right. Thanks. If there are no MOAPs, wait. So, yeah, on any case that doesn't have a MOAP, I'm gonna grant it. It's just, there's so many cases and I just don't have time to look.
Judge, I need to approach on Mr. Carter Peeler. Judge Peeler? Judge, my client's 29 years old. He's got a history of mental situations. He's here with his parents.
Where's mom?
Well, mom just went down to pay some parking, but dad is here.
Yeah, come up, Dad.
Judge, I mean, they have some, they have documentations of all of his mental challenges. I'm on the case, but I'll review the meds and all that, and it actually may be a better case for the PD's office. I'm not sure, but I mean, I know
Hi, Dad.
He gets nervous.
Thanks for coming.
Thank you.
There's no reason for you to be nervous. Really, it's not the end of the world. You've picked up a case, but it happens. When you do that, you dust yourself off, pick yourself up, and you move on. All we want you to do is just don't violate the law. Do you have a Texas driver license? Do you have liability insurance? Okay, you can continue to drive, just be careful. If you happen to get into an accident, stop. It's not the end of the world. That's why you have car insurance, so that if you get into an accident, they're there to help you with what happened. They'll even give you a lawyer to represent you. That's why you pay for car insurance. Really.
I didn't know they give you a lawyer.
Well,
Your insurance company.
Not every single time, but
Okay.
you know, like if someone were to sue you and you have car insurance, typically there's a lawyer to help you out with these cases. Yeah. So that's why you pay for car insurance. That's why it's as expensive as it is. So I'm not putting any conditions on your bond, okay? Just be careful and be safe. That's it. We've given you a lawyer to stay in touch with John, and he'll tell you how to navigate through this issue, and that's it. Do you have any questions? The only other thing I'm going to tell you is that if you take medication, psychotropic medication, continue to take it. When you stop, I see so many people, they start taking it and they start to feel good. You know what? I don't need this anymore. I feel great. They stop taking it, boom, same thing starts happening. They evolve in that circular, just end up in purgatory because they stop taking it and they end up back into the same situation and into bad things start happening. If good things are happening when you take the medication, keep taking it. It's there for you to do well and to be well, to be better. And that's what the medication's there for. Don't stop taking it, because when it does, that's when things spiral out of control. We're here to help you. That's why we have lawyers. That's why we have, okay? Questions? Just relax. Everything's fine. If you guys need anything, we're here for you. You can always come back here and then we'll help you out. We'll set you off a month. If you need anything, just come back and we're here for you, okay? All right, guys. Take care.
Need to sign?
No, just a reset.
Pause right here, because this is where the case turns. A .025 BAC, cocaine and marijuana in her system, and yet she's not charged with intoxication manslaughter. Why? Causation. The law doesn't punish intoxication alone. It has to prove the drugs caused the death. And that gap, it's about to explode in this courtroom. Do you agree with that line, or does accountability still matter here?
You are Alvaro Betancourt. Yes, sir. Mr. Betancourt, you're charged with assault of a family member. You are facing up to a year in jail and/or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On November 4th, 2024, officers were dispatched to an address in Harris County, Texas, in reference to a family disturbance type call. The caller was witness Graham, who called 911 stating that he heard the complainant in the background of a phone call crying, stating that she was having a domestic disturbance incident with her ex-boyfriend. Officers arrived on scene that was indicated by the witness and spoke with the complainant. The complainant stated that the defendant is an ex-boyfriend of hers who she shares a child with. She stated that on this date they were in bed together when the witness called her. Witness Graham, and the defendant saw the witness call her, became upset, and stated, "I will kill you and her and go about my day." The complainant began to cry and told the witness she was having issues with the defendant. The defendant then grabbed her by the wrist and began to physically slam her into bedroom walls, causing pain to her upper body and pushing the complainant into the hallway outside her bedroom, where he again slammed her into the hallway walls. This was witnessed by her 8-year-old juvenile daughter.
So the daughter sees this happening.
The daughter sees this happening.
Not his biological daughter, though, right?
No. His biological daughter is 7 months old, so there's 2 daughters.
So he does have children with her.
Yes. Officers pulled the defendant's photograph, who the complainant positively identified as the defendant. She stated that they've been separated for over 6 months, and the defendant became angry when the complainant told the defendant she had a new relationship already. Officers tried to reach the defendant but were unable to.
So she has a new person.
So she indicated, Judge.
Okay. Mr. Betancourt, I'm going to find that there's probable cause to go forward with the case. I'm entering now what's called a magistrate's order for emergency protection. This is a court order that identifies Irma Becerra as a protected individual. He cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, the stalking statute. You cannot stalk, threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works.
If I may, my understanding is that the complainant and my client are living together, that they're still together. I was wondering if you would be able to do a no threatening and harassing content, saying that they also share a child.
Until I know what she wants, I'm not going to do that, right? They've been unable to reach her, and according to what they're saying is that she has a new beau. So I don't know. Until I know, I like to honor the wishes of the complaining witness. And until I know that she wants to have contact, I'm ordering you not to have any contact with her. I don't care what you're going. I don't care what you're doing. No means no. I don't care if there's a burning building and she's in there, you have to go save her. A court order is a court order. If you violate this, I'm going to put you in jail. Are you a United States citizen? I don't know if you are or not, but if you're in this country without permission, if there's any problem with your immigration paperwork and immigration finds you in custody, they will put an immigration detainer and you will be stuck in there until this case is over with, and then they'll ship you off to immigration. Don't violate any of these conditions. Don't pick up a new case. No contact, no weapons. Do you understand?
Sure.
Anything else?
No, Judge, that's all.
Now, have you run his NCIC? What kind of criminal history, if any, does he have?
Just a moment, Judge, I'm pulling it up.
You need to do a bond because there's no bond that's set.
And he has a bondsman here. I was wondering if you'd approve of Walton. I was wondering if you.
Well, if he has no criminal history, I was going to give him a PR bond.
That works as well.
But I don't know what his criminal history is, so.
As for criminal history, I see a sexual assault out of Rio Grande City that has no disposition. A driving license invalid out of Brazoria County. That was a conviction.
That would be, curious about what happened with that sexual assault.
Another driving with license suspended in Brazoria County. Another driving with license invalid in Montgomery County. And then a aggravated assault with a deadly weapon in Brazoria County. But that was, I see a final pleading of not guilty, but I see no disposition on the case.
We're setting your bond at $5,000 and he'll have to make a surety bond. Do you have a Texas driver license, Mr. Betancourt?
Yes, I still have it.
Does he have, can you run his license to see if he has a license?
Yes, Judge, I'm running it right now.
I'm ordering you not to drive any vehicle unless you have a Texas driver license and liability insurance in your name, Mr. Betancourt. Do you understand? Like I said, I take public safety extremely serious, and I will do everything in my power to protect the public. If that means putting your bond at $10 million, I'll do it in a heartbeat to protect the public. So be careful when you're out there. Actions have consequences. Do you understand?
A valid driver's license.
Okay. Yes, sir. All right. Now you have a lawyer. It's your responsibility to stay in touch with them, and they'll tell you when you have to come back to court. If they tell me they can't get a hold of you because you're playing games, I will issue a warrant for your arrest. You will not get any more PR bonds. No, or you won't get any PR bonds. Do you understand? Okay. Do you mind drafting all those conditions, please?
Yes, Judge.
Okay. All right, guys. Thanks.
Thank you, Judge. Maybe
All right. He cannot go because we need to do everything, and then you said he has a bonding company here, right?
Yes, Judge.
Okay, we'll release him to the bonding company here when we get all the paperwork done.
Thank you,
Okay,
Judge. I'll go ahead
thanks.
and resend him in the meantime and have him put.
Don't, because he still has to post bond. Once he posts that bond, you'll get a 7-day setting. When you get that 7-day setting, feel free to come up here and we can give you a different day,
Yes,
you know?
Judge.
Yeah, okay,
Judge.
Ricardo.
Judge, what was the